antitrust.pdf. So, back to my commentary here, and it's taking two videos, undoubtedly, that since the Nixon administration starting in 1969, there has been little meaningful antitrust enforcement by government, with the courts making it virtually impossible for private enterprise or private enforcement of the antitrust law. The enforcers wind up working for the regulated companies or their large corporate employers at substantial salary increases over their salaries as public officials. Now, after 40 years of private enforcement experience, here is what I believe is needed to obtain a substantially more effective enforcement of the nation's antitrust laws. I'm going to first of all put in one more, which I forgot to add in my notes here, and that is that every town, village, and city in the United States should have its own attorney general, which I call generically a town attorney general, for the purpose of enforcing these laws that we see are not being enforced by the regulators, both federal and state. We need to have, at the lowest level of enforcement, we need to have the ability of these entities, the lowest level of governmental agency or towns, to start enforcing these laws. We have 40,000 such entities. We need 40,000 enforcers, with a decentralization of the enforcement of this law, similar to the way that the criminal law has been decentralized and brought down to the county level. We have to bring a decentralization of these civil enforcement of federal and many state laws down to the level one step below the county at the city, town, and village level through the appointment of a town attorney general. Now, there's the other points that I wanted to make. We need a statute requiring the Justice Department to look into every private antitrust action filed in the federal courts and report to Congress the results of the investigation, together with the names of the individuals involved in the investigation and report, to be able to identify Justice Department officials who are failing to do this important new supervisory role, and for them to be required to testify before Congress on their activities or lack thereof. Under the Copyright Act, the court clerk is to give notice of the filing of any copyright infringement action to the Register of Copyrights. Why don't we have something similar in a more important law, the one that really our personal liberties in this country are dependent on, the antitrust laws? 2, private lawsuits should be permitted under statutory provisions of the antitrust statutes, where the government and state attorneys general currently are the only ones who can bring suit. We have seen that the federal government cannot be relied upon to be the only one permitted to enforce the nation's important laws. For example, private suits cannot be brought to enforce the unfair competition prohibition of Section 45 of the Federal Trade Commission Act, and just incidentally, there's no private right of action for enforcement of the very important Sarbanes-Oxley Act, which requires full disclosure by corporations that are publicly trading. It's not an antitrust statute, but it has very important implications because we don't know what's going on unless they disclose to us what's going on. 3, we need congressional hearings to get input from private litigants and their lawyers as to what changes are needed to overcome the substantial impediments that exist, both in the statutes and in court decisions, to having the antitrust laws effectively enforced by private lawsuits. The courts have made it too costly and difficult for private litigants to enforce these laws, and I know because I've been doing this since the year 1970. So I have been here, I have seen it, and I am telling you it is impossible for private litigants who are really injured. They don't have the money, the costs keep mounting higher and higher and higher, and a lot of it is totally unnecessary, truly just barriers to enforcement of the law, designed deliberately to obstruct, and it does, and they did a great job for which I must congratulate them. They have totally subverted the intention, the meaning, and the usefulness of the antitrust laws as a result. Perhaps the courts were thinking, as we saw with the U.S. Supreme Court in that 2007 decision, that because the FTC and the Justice Department were already tasked with enforcement of the antitrust laws, that there's really no need for private enforcement. You see where the economy is today, that's because we didn't have government enforcement, and we weren't encouraging private enforcement by reason of some of these things that I've already said. A very important thing in addition is that the role of economic experts needs to be re-examined. The requirement that they be used by antitrust plaintiffs imposes a huge economic burden on the plaintiff and its lawyers, and generally destroys the financial ability of the private litigant to fight effectively or at all. We have seen that the economists do not know what is really happening in the economy or how to cure the problem. It seems we're pretty clear in that respect. No matter who they are, at the top of the pack, they don't know what to do. Looking back in future years, we are going to be the butt of many jokes of how we required litigants to present costly economic astrologists to help prove facts before our juries. We have got to rethink whether economists are required to be used in antitrust litigation, or is it just another barrier that has no meaning? And that is what I think you'll find. There's no meaning to it. It's just a barrier, costly, and it deprives the country of effective antitrust enforcement. It's killing antitrust enforcement. The rich corporations hire economists to invent economic drivel, and I'm telling you, I have seen nothing but drivel. And you don't even understand what they're saying. It's drivel, designed to confuse and obfuscate, and it's very effective in that. And the impoverished litigant loses because he can't afford to offer opposing drivel. Economists generally cost about $100,000 to $1 million or more for each side in an antitrust action that actually gets into discovery. In one case, the plaintiffs paid more than $1 million to the #1 economist in the nation, and the judge threw out the $1 million job, totally threw it away, and the plaintiff lost as a result. While Congress and the Obama administration are handing out trillions of dollars to failed institutions, they should set aside $100 million as a fund for the financing of private antitrust lawsuits, for which the fund would obtain a percentage of any recovery, such as 30%, which fund could undergo spectacular growth if well managed. 6. Antitrust practice, as practiced by major law firms during the past 30 years or so, is to explain in great detail to the favorably disposed regulators why they should permit the corporate clients to go through with any proposed merger or acquisition, thereby enabling the large corporations to eliminate competition and become so large that we supposedly cannot allow them to fail or be able to regulate them at all. This is not enforcement, but wholesale abandonment of the purpose of the antitrust statutes. My name is Carl Pearson. I have discussed most of these concerns in other YouTube videos and in several websites. You might take a look at my lawmall.com website, and if you want these statutes, the antitrust statutes, here it is again.